I'm Matt Teal, the president of the Montana State Bar, and it's my pleasure to introduce the professor who's going to give an introduction to the cases you're going to hear this morning. Looks like everybody's finding a seat. Pretty good. So if there are any students that still haven't found seats, and the seating that was provided here on the sides is full, there are still seats here in the middle that you can come join the attorneys, so feel free to find a seat. Professor Cynthia Ford, University of Montana Law School, has graciously agreed to provide the case introduction. I will not give her a long introduction. You know her well. She has, time flies, and we all know about the stories that the people before us told about Duke Valley. Well, a generation almost just passed, and Cynthia Ford has educated nearly a generation of Montana lawyers in civil procedure and evidence, and I was in her very first class. So it's my pleasure to introduce Cynthia Ford for the case.
And a great thing about teaching at this law school, as I look out, I see so many of you who were in our classes there and of whom we're so proud. And then time does fly, and I see a lot of you with whom I was in practice, and it turns out many of our hairs have turned white, or even gray. The argument is scheduled to begin at 10, and one thing we trial lawyers know is that you begin on time, particularly before the Supreme Court. So I've got just a little bit, I've got 20 minutes, and Shane Vanetta is keeping time for me, to explain both the court systems in general and the background of this specific case, which I think you're going to find enthralling, although right off the bat you might not think an insurance surplus lines coverage action is that sexy. Turns out it is. Who knew? Anyway, I do, for especially the benefit of all the students here, and we really are so excited to have you share this Montana Supreme Court argument in Missoula here with us. I want to just give a quick overview of the court systems in our country so that we can situate ourselves in the Montana State Supreme Court, which this has turned into the hearing room for them. All three types of courts in the United States have in common the goal of resolving disputes between parties. In criminal cases, the parties in dispute are the government on one side, the state, the United States, or the tribal government, against a defendant accused of violating a law designed to benefit the public. The other kinds of cases, the kind we have here today, is a civil case between two private parties. But the resolution of that case, the parties have not been able to get to on their own, and so they have resorted to the court system to resolve those cases. There are, as I said, three kinds of court systems in the United States. There is the United States court system, a single system which spans the entire United States. We are located in the U.S. District for the District of Montana. And federal court cases hear and decide cases under federal law or between citizens of different states, for instance, Montanans versus a person from Idaho. That is not where we are today. Similarly, there are 7 tribal courts just in the state of Montana, more than 350 across the United States. Each tribal system is set up by the governing tribal body through the Constitution and tribal ordinance, and those courts are able to resolve certain civil disputes and certain criminal disputes. Again, we are not there. Instead, we are in the state court system, obviously, for the state of Montana. And like all states, our court system is set up by our state's constitution and our state's laws enacted by our legislature. Our power, however, can be and sometimes is limited by federal action. In this case, we've got, in Montana, we have got a 2-level court system. The cases generally begin, you know, a case worth more than $12,000, in this case is more in the $12 million range. Those cases begin in the Montana district courts, and there are 56 district courts in the state of Montana set up to hear disputes arising from, as here, a kind of contract. In those 56 district courts, we have only 46 elected judges, and that's because many district serve more than one county. There are 22 districts altogether. Missoula, where we're now located, is in the 4th Judicial District, and that covers Missoula and Mineral counties, both. There are 4 judges, just for example, in the 4th Judicial District: Judge John Larson, Judge Dusty Dayshaw, Judge Karen Townsend, and we actually have with us here the newest judge, Judge Leslie Halligan, sitting in the front row in the purple. And also, there are other staff who have more limited judicial. Filed in that year, 2014, 53,282 cases, and that's an increase of more than 1,000 from the year before. Those cases not resolved, and the district court enters an order, a judgment, indicating a loser and a winner. A loser in the district court has the absolute right to appeal to the Montana Supreme Court, and that's different from the federal system where the U.S. Supreme Court only accepts a certain, very few actually, petitions for review. Here, the Montana Supreme Court is required to take all appeals from the final judgments of the lower courts, and that's exactly what we see happening here today. You will see that there are 7 justices on the Montana Supreme Court. The Chief Justice is Mike McGrath. The Associate Justices are Pat Cotter, Jim Rice, Mike Wheat, Beth Baker, Lori McKinnon, and Jim Shea. That's a generational thing because he also was in the first class I ever taught. So that's when you know you're getting old, is when your student is on the Supreme Court. So I'm clearly there. In 2013, there were 666 new appeals filed, 380 opinions issued by the court, and 848 cases closed. So you can see that not every case decided by the district court goes up to the Supreme Court, but a lot do, and that's a big workload for a court of this size. We do not, in Montana, have an intermediate appellate court, so there's no intermediate group that stands between the trial level and the Montana Supreme Court. The majority of cases submitted to the court are decided just on the written briefs, which are submitted by the parties. And in those briefs, the parties discuss the applicable law. They identify the errors that they say were made by the court below, and the reasons, that's the appellant, the party who is complaining about what happened below, and identify the reasons that they think that the court's judgment below should be overturned. Of course, on the other side, the appellee, the party who's been called to the appeal, defends what the district court did. It said, I won, so it's perfectly right, and you should keep it as it is. Occasionally, about 30 times a year, the Montana Supreme Court decides that a case requires more discussion than just what is in the written briefs, and in those cases, the court holds oral argument. So you can see they get about 660 cases a year. They only hear 30 cases a year for oral argument. Most of those oral arguments take place in the Montana Supreme Court courtroom in Helena, but the court also is dedicated to bringing its work to the public, and so schedules several arguments like this around Montana every year. We are lucky that one of these occurs here in conjunction with the Bar Association meeting There will be another one, I believe, in April in conjunction with the law school's Law Week. The oral arguments are tightly structured and timed. Counsel for each party is allowed a limited amount of time to make the argument, generally from 20 to 40 minutes. And when the court sends its order to the parties saying your case has been set for oral argument, it tells them exactly how long they have. That order in this case was issued in July of 2015, and that order gives the appealing party, Westchester Surplus Lines, 40 minutes, and the appellees have got 30 minutes. The Deputy Clerk of Court, Rex Palmer, sitting over there.
Right. Rex, right.
I got that wrong. Anyway, we'll keep time, and he'll signal the opposing lawyers when their time is up. Of course you're not Rex Palmer. I am so sorry. Okay. There's been a large cast of lawyers on this, involved in these two joint cases, but today I think we're going to have argument from only one person for each side. Is that correct? So the lawyer for the appellants, Westchester Surplus Insurance Company, is sitting right here. His name is Jonathan Hacker, as we say in Montana. Hope this is not offensive. He's not from here. But his sister lives here, I just learned. Great. He, in fact, lives in Washington, D.C., and he's with the law firm of Mulvaney and Myers. He graduated from the other UM, the University of Michigan Law School, in 1995. Because he is not a regular practitioner in Montana, he had to go through a special application process to be admitted, and it's called Pro Hoc Vice. On the other side, the arguing lawyer for the appellees, the trucking company homeowner conglomerate, I call them, is Roger Sullivan, and he's from the Kalispell law firm of McGarvey, Herberlin, Sullivan, and Lacey. He is a graduate of this UM law school and has been recognized as a super lawyer at least 6 times. So we have 2 rock stars who are going to argue this case here today. So we're very lucky. Let me go on to the specific case. It's actually 2, there will be a test, you students. It's actually 2 separate cases stemming from the same basic facts. So here we are on September 11th, 2015. This all began on Wednesday, April 2nd, 2008, when on Highway 35, just northeast of Polson, along Flathead Lake, so when you come into Polson, you take that right and go up the east side, there was a truck accident. And a newspaper account at the time said this: speed was a factor in the accident that occurred when the tanker pulling a pup trailer hit the edge of the road and overturned. Keller driver John Bjorken was cited for careless driving. Keller Transport was working under an agreement with Wagner Trucking to haul gasoline owned by Erickson Petroleum. That accident resulted in a spill of 6,380 gallons of gasoline. And that gasoline entered springs along Flathead Lake and impacted the groundwater as well as the lake itself. 5 homes located near the accident had to be evacuated so that the cleanup could begin. That remediation work took more than a year, from April 2nd, 2008 until June 2009. Those homeowners have alleged that they were inconvenienced greatly and that their property was permanently damaged. Despite the remediation, they allege that their property still is not and never will be back to the pre-accident condition. So now that path goes from that accident to the courtroom and now here to the Holiday Inn. The appeal is from 2 separate cases. The first one was in Lake County District Court in Polson. And in that case, not surprisingly, the homeowners who were affected by the spill sued the trucking companies for money damages. So I'm going to call them the homeowners versus the truckers. That was in Montana State Court, as I said, in Lake County. When you make that kind of claim, the lawsuit itself is just the 2 parties, the aggrieved parties and the alleged negligent parties. In In fact, though, the truckers had insurance. Insurance companies, by law in Montana and everywhere else, are not joined in that lawsuit. They operate back here. The jury, if the case goes to trial, is not supposed to know whether or not there's insurance. The fear being that if the jury were to find out there was a ton of insurance, they would ring the bell more than otherwise. Or if they find out there's no insurance, they might be very, very cheap with their damages because they feel that the money will be coming right from the pocket of the negligent party. These truckers, as I said, did have insurance in the background. They had, in fact, two insurance companies. One, the primary insurer, is called Carolina Casualty. And that insurance policy, in exchange for the premiums of the truckers, Carolina promised to provide and pay legal defense costs if there were ever an alleged negligence claim against the truckers, and then to pay damages awarded up to the policy limits. So that's Carolina. The second insurance company is Westchester Surplus Lines Insurance Company, and they issued what's called an excess or surplus policy, meaning that they were going to be on the hook to pay only if the truckers caused damages greater than the limit of the Carolina primary policy. And their policy has language that indicates that Westchester Surplus does not have a duty to defend per se, but may participate in the defense if it chooses. The facts in this case are that for a while, Westchester Surplus did that and organized and paid the cost of the defense. The whole time it was doing that, it kept sending what we call reservation of rights letters to both the truckers and Carolina, basically saying it's still not obligated to pay for the defense of the lawsuit, and it would stop when it spent the $4 million limit on the case. It spent the $4 million and then stopped the defense. Westchester is here before the Montana Supreme Court because it says we spent our $4 million and so we're out. We have no more liability in this case. The homeowners and the truckers disagree. They say Westchester started into the defense voluntarily and they should not be allowed to put down the burden and walk away. They say that when Westchester did that, Westchester breached the insurance policy, and that breach means that it waived its policy limits. So, back to case one. Case one, there was apparently a settlement offer where the truckers, the homeowners offered to settle the case and walk away for the combined policy limits from Carolina and from Westchester Surplus. And that offer was rejected. So then the truckers and homeowners themselves entered into settlement negotiations and arrived at a resolution. So that case has never gone to trial. But the agreement between the truckers on the one hand and the homeowners on the other called for the payment of $13 million. So the homeowner said, we'll give up our claims in court. The trucker said, fine, and then we'll confess judgment in that amount. So that's the resolution of the case. The problem is the insurance company said, whoa, 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 whoa. By a third provision in that settlement, the homeowner said, when you confess judgment, we promise that we will not execute on that judgment. We won't go after you, the trucking companies, for the money. We will only satisfy that $13 million from the insurance companies. And the truckers then assigned their rights against the insurance companies to the homeowners. So now there's the insurance companies outside that case, and they're the only ones who are going to have to pay. So in that case in Polson, they asked the judge to let them intervene in the case. And that, in the end, it turned out that they could not. So they've appealed from that. Meanwhile, the insurance companies who weren't able to participate in that lawsuit brought a second lawsuit here in Missoula County called a declaratory judgment action. And if you're kind of a cool insurance lawyer, call it a DEC action. Asking that court to declare the rights and obligations of the insurance companies. Carolina has settled. They are not in the case anymore. So now it is Westchester alone Westchester versus the conglomerate of the homeowners and truckers. And they have asked the judge in Missoula, the district judge, to say they didn't have any, they met their obligations, there is nothing, they've done everything they need to do, and the judge did exactly the opposite. He found that Westchester had breached its obligation, that it had a duty to defend, and that now it has to pay the entire $13 million, and that that settlement was reasonable. So Westchester appealed from that order, and because these two cases come together, this appeal will consider both of those arguments. And I'm out of time, the court's about to begin, so that's the background, and you're going to hear much more about both of these. I want to say one more thing, which is also that the Montana Trial Lawyers Association has filed with the court, but will not be arguing today, a friend of the court brief, because they said this kind of settlement and how you determine whether or not the settlement was reasonable happens a lot. And so this case is important, and they've given their views also to this court in writing. All right.
Real quickly here, I've been asked, if you've got a seat next to you that someone could fill in, would you raise your hand so that some of these folks in the back can have the ability to move up? Thank you very much.
All rise and give your attention. The Honorable Justices of the Montana Supreme Court.
Please be seated. Good morning. We're very pleased to see you all here. As I guess you've heard, these are cause numbers 12-06-000 and 14-0278, Westchester Surplus versus Keller Transport. Before we start, I'd like to, for those of you who don't know, introduce the members of the court. Far in to my left is Jim Rice, Justice Jim Rice, and Justice Jim Shea, Justice Lori McKinnon, Justice Beth Baker, Justice Mike Wheat. I'm Chief Justice Mike McGrath, and Justice Patricia Cotter is unable to be here today, but she is participating in the case and will review the arguments online. I would also like to take a moment and just acknowledge that we today have ABA President Paulette Brown with us. And President Brown, we appreciate you coming to Montana and attending our argument. You can critique us afterwards. Our counsel ready to proceed? Mr. Hacker.
Good morning, Your Honors, and may it please the court. The excess insured in this case, Westchester, did everything its policy required and more. When the $1 million in primary auto coverage issued by CCIC was exhausted, Westchester immediately began paying cleanup and other costs pursuant to its excess coverage. Then, when the insureds, Keller and Wagner, were sued for the oil spill, Westchester did something not required by its policy it agreed to pay their defense costs, even though its policy explicitly stated that Westchester, quote, shall not be called upon to assume charge of the settlement or defense of any claim made or proceeding against the insured. From the very start, however, Westchester explicitly stated that it would only pay defense costs until cleanup costs reached its $4 million aggregate policy limit. And importantly, Keller explicitly agreed that the aggregate limit was $4 million. Westchester then provided regular reports advising how much remained on the $4 million limit and advising Keller and Wagner to prepare for the cessation of payments once the $4 million was expended. When the $4 million was exhausted in December of 2009, Westchester immediately advised Keller and Wagner, and CCIC promptly reassumed responsibility for the defense payments.
At that point, counsel, had there been a claim made for excess insurance or additional insurance above the $4 million?
At that point, no. Keller, there wasn't. Keller and Wagner did not at that time, or at any time prior to those, in the many months prior to that, ever suggest that the policy had not been exhausted, or that there was an additional $4 million available under this TGL coverage.
Your brief indicates that a claim was made by the plaintiffs for additional coverage in August of 2010, which would have been about 8 months after you withdrew. Is that the timeline that claims occurred?
Right. It was only many months later, in August, that was the first time anybody suggested that CGL coverage could apply, or that there was an additional $4 million in coverage limits under the CGL coverage, and that was after Keller and Wagner's counsel began speaking to the Homeowners Council. It's on the basis of that post hoc theory that there is an additional $4 million in aggregate coverage under the CGL policy that the homeowners today now are arguing that Westchester's policy was not exhausted when it stopped paying the defense costs in December of 2009, and that Westchester therefore at that time breached the duty to defend, even though the policy explicitly says there is no duty to defend, and even though Westchester did exactly as it promised all along.
Well, counsel, irrespective of the duty to defend in the policy, if there was statutory, if there were additional limits to the policy under the CGL, there was a statutory duty to defend, correct?
No, that's not correct with respect, Your Honor. The statutory duty doesn't apply. It only applies unless a contrary intention appears. That's what the statute explicitly says, and the District of Montana in the bank insurer case applied that to correctly understand that there is no duty to defend if the parties agree that there is no duty to defend.
Counsel, if you could help explain item 6 under the policy. We've got the 4 million occurrence, 4 million aggregate. What does the second line describe? 4 million products, completed operations agreement, excess of the limits indicated.
Right. It describes basically nothing, Your Honor, because there is no products completed operation coverage under the primary policy, and therefore there's none under the excess policy. So it's meaningless language in the excess policy. It is indicative of one thing, though, because it mentions aggregate for what we call the PCO, products completed operations coverage. And I think that does illustrate what one does and what one sees in other cases where you have an aggregate that applies to a specific coverage. You say PCO has an aggregate, in that case, of what I think was $4 million. But when you just say general aggregate and don't specify that that general aggregate applies, or any aggregate applies to a particular coverage, then general aggregate means what you would think it means. It means general meaning covers everything, the aggregate covers everything, and it means, in fact, what the insured here thought it meant all along until it began communicating with the Homeowners Council.
So let me make sure I understand what you're saying. This item 6, which specifies the limits of insurance, the second line of that is totally irrelevant because there's no coverage provided for products completed operations.
That line as to products completed operations is irrelevant, yes. That reference to the PCO coverage, it just doesn't apply here because there is no PCO coverage. That's all I need to say.
So give me an example of what PCO coverage would cover.
Well, if there were coverage in PCO, for PCO coverage, it would be like in the Ellinghouse case, I don't remember that case, but that's a situation where the insured in that case laid a sprinkler system in a golf course, and he had a policy that covered his premises and that work. And then 3 years later, or some number of years later, somebody electrocuted somebody and they blamed the sprinkler system. If there was PCO coverage, because his work was completed, that's what that would cover.
Well, counsel, under this though, under the item 6 of your declarations, of Westchester's declarations, it's 4 million each occurrence, 4 million general aggregate. This was a follow form policy that specifically references the Carolina policy. So in the Carolina policy, it has 1 million each occurrence under auto liability, then 1 million each occurrence and 2 million general aggregate that's specifically separated into the CGL. I mean, so isn't it a fair reading that the 4 million aggregate is just under the CGL and the 1 million is just to the automobile liability policy under the Carolina policy? And if that's the case, and this is a follow form policy, then why isn't the same rules applied to the Westchester policy?
Because it only follows form unless it doesn't, if I could be stated so.
Well, let me ask you, but I mean, isn't that a reasonable reading of the Carolina policy?
Well, it's an accurate reading of the Carolina policy. The Carolina policy is an example of what I was saying. It specifies that the general aggregate limit applies to the CGL, and it doesn't have an aggregate limit that applies to the auto coverage. It's exactly what one would want to do if you wanted to have an aggregate limit for a specific coverage. The Westchester policy, the excess policy, is written differently, and it's perfectly...
Except for the fact that the follow form provision in your excess insurance policy specifically says the insurance afforded by this policy shall apply in like manner to the underlying insurance described in the declarations, which is what we've just agreed that that's a reasonable reading in the Carolina policy.
Except the phrase right before the phrase you just read says, except as I've stated herein, which is a recognition of the standard point that excess policies only follow form unless their conditions, their terms differ. And
So where in the except as stated herein
it's in the limits of liability are different in the excess, between the excess and the primary policy, which is a standard relationship between excess and primary policies. Excess policies almost never follow form, and we cite cases in the brief that say the one thing that they're like always different on is the limits of liability.
But the limits of insurance only say 4 million each occurrence, semicolon 4 million general aggregate.
Right, which is different from what the primary policy says. The primary policy says there's a general aggregate for CGL. The excess policy is just an excess policy covering all kinds of risks. It doesn't have separate coverages. It just covers whatever risks there are, that aren't expressly excluded, risks that are encompassed by the primary policy. And so you purchase, in this case, $4 million in excess coverage. Whatever happens, the limits aren't written the way the primary limits are, where it says there's a specific per accident limit, no aggregate there, and a CGL limit per occurrence, and a general aggregate limit for CGL. That's not how the excess policy is written. That's the way in which they're encompassed.
One of the cases that both parties cite is the Weyerhaeuser case from Washington, and in that case, the excess policy specified some coverages for the excess limit and didn't specify others. And the court there said, well, if the insurance company had intended to have an excess or a general aggregate for property damage, it could have said so. So it seems that kind of cuts both ways with your argument here that because there is a specific aggregate stated for products completed operations, but not specifically stated for the others, couldn't that cut against the argument that you're making?
With respect, Your Honor, I think it cuts entirely in our favor, Weyerhaeuser, both by its example and by reference to the language we have here. So in Weyerhaeuser, what happened was there were specific, it's just like the example I was discussing earlier, there were specific aggregates assigned to certain of the coverages by terms. The personal injury was whatever it was, $1 million in aggregate. And then when they got to the property damage, there was no aggregate specified. And the insurer tried to argue, well, the aggregate nevertheless applies to the property damage coverage, even though there's an aggregate specified for everything else, but not for property damage. And the court said, not surprisingly, that argument doesn't work. There is no, if you wanted an aggregate for property damage, you should have said so. Here, the policy sort of works like the Weyerhaeuser policy in that, with respect to the PCO coverage, there is an identified aggregate limit. So we know what that aggregate limit is. But other than that, there is a general aggregate limit of $4 million.
So in this case, if we were dealing with, for example, a claim under the auto coverage and a claim under the PCO, in that case, could there be $8 million?
Yeah, it's possible, and that's not raised here, and the PCO doesn't apply, but that would be an example. I'd want to think about in relationship of the policies and everything, because that's not been presented, it hasn't been briefed, but that is an example of the kind of thing that could occur, yes.
All right, so just one other question. The district court seemed to rely on the MCS 90 endorsement to find an ambiguity. Could you talk a little bit about that?
Absolutely. The MCS 90 does not create any ambiguity, most simply because the key provision of the MCS 90 explicitly says, quote, all terms, conditions, and limitations in the policy shall remain in full force and effect as binding between the insured and the company. It doesn't change the policy limits. That's not what the MCS 90 does. The MCS, how do we know that? The MCS 90 says so.
Well, except for the top line in the second to largest print is this endorsement changes the policy.
Right.
So you're saying notwithstanding that bold heading at the top that it didn't change the policy.
It does change the policy in the sense that it creates a surety obligation that lies with the insurer in the first instance to pay the injured party if there's not sufficient insurance and it's otherwise covered by the terms of the MCS 90. And then that surety obligation, of course, shifts back to the policyholder eventually, which owes the money back to the insurer. What this is saying is it doesn't change the relationship between the insurer and the insured.
How does that say that to a reasonable consumer of insurance in this policy?
Well, I think a reasonable consumer of insurance would read the declarative sentence that says it doesn't change, it explicitly says all terms and conditions and limitations in the policy shall remain in full force and effect as binding between the insured and the company, the insurer. That's unambiguous language.
So what is that consumer supposed to think of in the sentence that's next to the box that's checked that says this insurance excess and the company shall not be liable for amounts in excess of $4 million for each accident? What did they take to that?
I mean, a couple of things. That correctly describes the per accident coverage. It says nothing about whether there is a general aggregate limit that would preclude a claim for CGL coverage. The MCS 90 has zero to do with CGL coverage, right? It's only about trucking accidents in particular. So it wouldn't say to anybody anything about the general aggregate limits of the policy, or more particularly, whether or not a statement that says the general aggregate limit of this policy is $4 million applies to the CGL coverage. It applies to the whole policy, including both together, the accident and the CGL coverage. Is
the MCS 90 form that's part of this policy identical to the language in the federal regulation?
Yes.
It was not drafted by this, specific to this policy.
That's correct. It's a form, and another court has held that under those circumstances, you don't apply the usual rule that you construe it against the insurer which drafted the policy, since we didn't draft this language, but I don't even think there's any ambiguity to address. I do want to make one kind of threshold point, though, that exhaustion is no doubt relevant and important here, whether or not there's actually exhaustion and what the actual policy limits are. But there is the antecedent point that we never told the insurers anything other than we were only going to provide pay defense costs up to the $4 million policy limits, and in particular that we were only going to pay $4 million. That's exactly what we did. Even if it were true that there were $4 million more in indemnification coverage, that would have nothing to do with a breach of the duty to defend, because there's no basis for the insurer saying, well, I relied on your statements and did something. The insurer here didn't rely on any statements, didn't do anything different, because our statement was simply, we're going to spend up to $4 million in cleanup costs. When that $4 million is expended, we will not be providing a defense. We reserve our rights, and at that point, you need to take care of things yourself. In particular, the case goes back to CCIC, which did, in fact, of course, live up to its defense obligation. So there's really no argument for breach of the duty to defend here, even accepting what I think is incorrect, even accepting the insurance premise, or actually it's the homeowner's premise, not the insurance premise, the homeowner's premise, that there was an additional $4 million in CGL coverage, $4 million that the insurers themselves never once pointed to during the relationship between the parties when we were voluntarily paying defense costs. The only question in that circumstance, because the law is perfectly settled, including law from this court in the Ellinghouse case, is that an insurer is entitled to discontinue voluntarily paying defense costs so long as the timing of the withdrawal doesn't cause prejudice to the insured. The real issue basically is whether the insurer, by its statements or its actions, has sort of led the insured down the primrose path into thinking it's going to be taken care of, and then the last moment, the insurer, metaphors for the moment, pulls the rug out from under the insured and leaves it in the lurch on the, right as trial. That's what happened in the Ellinghouse case, and back in this court held that by promising a defense, and then just before trial occurred, saying we're not going to defend, it caused prejudice, and it was required to defend even though it didn't otherwise have a contractual duty to defend. So the insured here is required to demonstrate prejudice, and we submit it cannot do so because when we terminated the payments in December 2009, just as we had always promised we were going to do, trial was still more than a year away. There was no, we didn't leave the insured in any kind of.
So would you, clock's ticking here, I'm wondering if you could get to the reasonableness.
Absolutely. I think of it as sort of two arguments, both based on precedents in this court that were decided since the trial courts in the two cases issued their decisions. The two issues are, first of all, whether we were entitled to intervene in the underlying action and whether we were entitled to a reasonableness hearing. The intervention question, I think, is answered squarely by the Abbey Land decision of this court, which of course held that an insurer is legally entitled to intervene in the underlying action. Yeah, so.
Well, but my question about that is, do you read our opinion in Abbey Land as stating as a matter of law that an insurer may intervene anytime there's an underlying settlement between the insured and the injured party?
Well, I would say sort of, if I may, in that it rejected the argument in that case that the insured in that case said, well, the insurer can always intervene, it can always deal with this in the declaratory judgment action. And this court said, no, that's not the place to do it. It should be in the underlying action. I think it's fair, and this might be the overlap between Tidymans and Abbey Land, that the insurer has to demonstrate an interest. They can't just show up and say, well, I have an interest and therefore I want to intervene. There probably is some threshold inquiry, but that's not at all at issue here because it's clear that we had a very direct interest in the size of the consent judgment, given that we were the only party that was ever going to pay any amount of the consent judgment. And so we were entitled to, first under Abbey Land, to intervene, which didn't happen. So that alone is enough to reverse and remand for intervention in before the correct forum, the correct decision maker. And then beyond that, it's clear that we were entitled to a reasonableness hearing rather than what happened below, which is exactly what happened in the Tidymans case. The judge here, as in Tidymans, said, you are not entitled to a reasonableness hearing because you breached the duty to defend. And then, as in Tidymans, the court nevertheless went on to address in very cursory fashion the arguments for reasonableness and adopted the plaintiffs, the homeowners, proposed findings of fact and conclusions just across the board, verbatim. So you had the wrong decision maker making the decision, and it applied the wrong legal test. But the test the court applied in deciding whether or not there could be a reasonableness hearing was, quote, if a jury in the underlying case could have granted the amount based on, and this is the key, the evidence presented by the proponent of the judgment. The judge explicitly said he was only going to look at the evidence proffered by the homeowners, the proponent of the judgment, and refused to consider in the balance the evidence offered by Westchester. As the court said, this court made clear, this is the court itself describing its own actions, this court made clear that it does not intend to receive testimony and evidence during the hearing on homeowners' motion to find the confessed judgment reasonable and rightly so. Now, what the other side will say is, but there was evidence from both sides in the record which is accurate, but that's misleading because the court, as I've just shown you, refused to look at this side's evidence and simply said all that matters is whether the plaintiff's evidence would suffice to support a judgment, and Tidymans is dead square opposed to that.
Counsel, isn't that basically the exact standard that we apply when determining whether to set aside a jury verdict? In determining whether that jury verdict is reasonable, we decide whether it is the evidence in the light most favorable to the prevailing party, and that's what the district court did in this case, in determining whether the confession of judgment was reasonable.
But the question here is the prior question, is the summary judgment question as to whether or not the other side was entitled to the summary judgment on the question of reasonableness. And Tidymans answers that question. You apply the summary judgment standard and say, did the party proposing summary judgment, in this case Westchester, proffer evidence that if credited in the balance of all the evidence, a jury could decide in favor of Westchester. That's what should have happened here, what didn't happen here. The court only looked at the other side's evidence and didn't correctly view our evidence, consider our evidence, which came directly from the insureds themselves. Remember, this was evidence from Keller and Wagner that while the case was being contested, demonstrated that the restoration damages the homeowners were seeking would both have been economically or environmentally harmful and would have been inefficacious. Plus, we had arguments that they weren't entitled to restoration damages at all, given that the nature of the injury was not temporary as required by the Sunburst decision, that their whole point was, well, this is permanent damage, in which case you get the most remediation you can do. You don't get something to restore something.
But if we were looking at this evidence from a standpoint that could have been a jury verdict, I mean, would you dispute that a jury could have been free to disregard that evidence as well in favor of the plaintiff's expert evidence?
Well, except you would have to look, there would have been a cross-examination, right? There's no cross-examination here. That was the whole point. That's why you need a reasonableness hearing as opposed to just kind of looking at the evidence and saying, a jury could have gone this way. You could have that. You'd be looking at a jury verdict that after the fact was based on a proper examination of whether or not the claim to $13 million, ultimately $10 million, was a permissible claim under the law of this state and the facts of this case.
But if we presuppose that you breached the duty to defend, then you effectively waived the cross-examination.
I don't think that's correct. That's not, Tidymans holds to the contrary. That case, the insurer breached its duty to defend, and this court said you engage in that summary judgment examination of the competing evidence, not just one side of evidence, competing evidence at that stage, then you go to a reasonableness hearing, and at the outcome of that hearing, I recognize that the standard review would be different, but we haven't had that hearing. That's the whole problem here.
Why can't we leave it to the discretion of the trial court in setting those reasonable parameters, which is the phrase I think we did use in both of those cases?
Right. I think in Tidymans and in Adulan, you explicitly said, and we don't resist this, that the district court has the authority. It's not a full-blown de novo trial, which is the other side's a harbinger of doom. They say we're asking for this whole do-over. We're not seeking that. This court says that the district court has discretion to determine the nature of the evidence, how the evidence will be taken, and all of that. But we're entitled to at least the minimum due process of a hearing to determine, in fact, whether or not the confessed judgment was a reasonable outcome based on the law, as I say, of the state and the facts in this litigation.
And counsel, you're asking that we reverse Judge Langton's order from the 21st district and send it back to that district court. Now, Judge Langton likely would be substituted in that case. He's already shown a predisposition towards a homeowner. So where does that take you with the litigation?
Well, I mean, I don't know about the substitution. I don't want to prejudice one way or the other, but I do think under Adulan it goes back to that court, and it's not uncommon for cases to get remanded to a court on the merits, and a new judge has to evaluate the law and the evidence and everything. So I think that's what would happen. I don't think the substitution of a judge changes the rule of law announced in Adulan. If there are no further questions, I'll reserve the balance of my time. Thank you, Your Honor.
Good morning, Your Honors. May it please the court. Westchester's appeal hinges on its argument that there was a $4 million general aggregate limit, and it withdrew its defense of Keller and Wagner upon exhausting that limit. Westchester chose not to define the term general aggregate, and Judge McLean determined that Westchester's use was subject to multiple plausible meanings. In doing so, he was guided by basic principles of Montana insurance policy interpretation including construction of words and phrases, must attempt to reconcile all parts of the policy, including endorsements. Clearly, what Westchester refers to as the MCS 90 endorsement is part of the policy. Since Westchester chose not to define the term general aggregate that it relied on in denying payment under the excess CGL coverage, the district court appropriately looked to the entire policy, including the endorsements. The court noted that the policy included a public liability endorsement, what Mr. Hacker refers to as the MCS 90 endorsement, which, as Justice Shea noted, prominently at the top announced this endorsement changes the policy. This is significant because Westchester issued a single policy which provided excess coverage for both commercial automobile and commercial general liability provided by Carolina. He noted that the endorsement then goes on to state the limits of the company's liability apply separately to each accident, and any payment under the policy because of any one accident shall not operate to reduce the liability of the company for the payment resulting from any other accident. This language in Westchester's policy clearly contradicts the meaning of general aggregate that Westchester argues for. There is simply no way to reconcile the language in this endorsement that the contention that a single payment of $4 million can exhaust the aggregate, leaving no coverage for a second accident. The language in the endorsement must have meaning, and it must correlate to the policy coverage it is endorsing and expressly changing.
Mr. Sullivan,
Yes, Justice Baker.
does your argument about the policy language depend on the MCS 90 to support an argument that the policy is ambiguous?
Well, as the district court found, the policy in the first instance, it isn't ambiguous. It is clear. In the second instance, at the very least, the court determined that it was ambiguous.
Are you aware of, or can you tell us if there are any other cases that have used the MCS 90 endorsement to determine the limits, the policy limits?
I would point out, Your Honor, that that's not what the district court was doing. The district court was not using the MCS 90 endorsement to determine policy limits. It was using the MCS 90 endorsement as it was mandated by your case law, by Holman, and by statute to do. It was following the mandate that it must look at the entire policy, including endorsements, in order to determine what the undefined phrase general aggregate meant, and that phrase is found in the declaration sheet. Unlike Carolina, it chose not to define the term general aggregate. So it wasn't interpreting or construing the MCS 90 endorsement. It was determining what the phrase general aggregate meant that was found in the declaration sheet.
I guess what I'm having a little bit of trouble with in your position is that the application and of the MCS 90 is a matter it's a matter of federal law. I assume you agree with that preliminary statement.
I think what I would preamble it with, Your Honor, is that it's important that nowhere in the text of the entire Westchester policy and all of its endorsements do you find any reference to the MCS 90. That's a term that counsel for Westchester derives from cases that are explicitly dealing with the complexities and the technicalities of federal regulations, which in the federal regulations you will find reference to the MCS 90.
Well, except that, I mean, the language of the endorsement comes directly out of the federal regulations and has been construed by a number of federal courts that have held that the endorsement does not affect the
relationship or the policy as between the insurance company and its insured. In other words, it doesn't affect the policy itself. It's there to protect the public up to the limits, the minimum limits required by federal law. And so most of those cases hold that it's not even triggered unless you first have, no coverage or insufficient coverage. If, for example, if there was an uninsured vehicle or something like that. But we're not dealing with that scenario here because the $1 million clearly was the minimum required. So I'm just trying to reconcile your position with the other federal cases that say it doesn't come into play in interpreting the policy between the insurer and the insured.
I think, Justice Baker, the fundamental point is, that was pointed out by the Fourth Circuit in the THE Insurance Company v. Larson case, is that a case which was looking at an insurance policy with an MCS 90 endorsement, is that construction of the policy is a matter of state law. That's the fundamental point here. Continuing then.
Counsel,
Yes, Justice Rice.
You've said that you think the limits of insurance, item 6 in the policy, are clear, but in any event, they are ambiguous at worst. So what is your understanding then of the plain language of Schedule 6? 4 million each occurrence, 4 million general aggregate. How many occurrences do we have here, and how does general aggregate apply?
Well, Your Honor, the schedule of underlying insurance in item 6, that's referring, of course, to the Westchester policy. And the problem is that the general, what we are saying is that the limits apply to each, the commercial auto and to the commercial general coverages. And when we were pointing out to and arguing it below, we pointed out that this whole dilemma could have been avoided had Westchester defined the term general aggregate as the underlying policy Carolina did. And we also point out that there's a follow form provision here. And when you look at and follow the parallel coverages, you see that what it's describing in its schedule of coverages is it's describing in the underlying case, it says that there is a per occurrence limit for the commercial automobile, but that there is a general aggregate only for the commercial general. I think this goes to Justice Shea's point that he was discussing with Mr. Hacker a moment ago. And so it's perfectly reasonable for the reasonable insured reviewing the entire policy, including the parallel provisions and the follow form mandate, that the limitation for the general aggregate applies to the commercial general, and that for the commercial auto, it has that per occurrence limitation. And the reasonable consumer would find support in that in the very MCS 90 endorsement we were just talking about, which has a limitation of $4 million for each accident. And that $4 million for one accident does not reduce the liability of the company under the policy for any other accident. So,
Counsel, let me interrupt you though there, because I'm not sure you answered Justice Rice's question. I had the same question. How many accidents do you contend are at issue here?
There's one accident under the commercial automobile coverage, and there's a massive liability under the CGL coverage, because what happened here was that the complaint, and remember, under your case law, Tidyman, Staples, and otherwise, it's the complaint that really forms the basis for the determination as to what the responsibilities of the insurers are. And here, there was a commercial automobile accident, but remember, the gasoline is effectively dammed on the homeowner's land by virtue of Keller's environmental contractor constructing an interceptor trench that keeps the gasoline on the homeowner's property even as we speak. So that the large portion of the damages really are attributable under the complaint and under the facts, attributable to the CGL. Yet Westchester made the unilateral determination to allocate those to its commercial automobile. What we're saying is that there are properly, under the policies, there was coverage under both the commercial automobile and the commercial general coverages, and that only $4 million has been paid when properly there should be $8 million available. That's, excuse me, yes, Justice Kennedy.
Is there any dispute that the CGL policy has been implicated?
Initially there was. In the initial letter from Westchester, they denied that the CGL was implicated, just as Carolina did. So that during the unfolding of these events, both insurers said there is no coverage under the CGL. Westchester later retracted their error and then conceded that there was coverage under the CGL. So basically, I think that we've understand that what Judge McLean did is, he looked at the entire policy, he read the entire policy, he noted that it had an MCS 90 endorsement when he was looking at the issue presented to him by the parties, which was, what is the meaning of the term general aggregate? And in reaching his conclusion that that term could, even under a plain meaning reading by an average consumer of insurance not trained in the law of insurance, could reasonably conclude that there was coverage for, under the commercial auto policy, there was a $4 million coverage, and under the commercial general liability, there was also an additional $4 million in coverage. So where does that leave us? It leaves us with one coverage untapped. Westchester concedes that it has paid nothing under the $4 million general aggregate limit available under Westchester's excess policy. Nevertheless, at great peril to its insurance, it withdrew its defense and it completely denied the existence of coverage beyond $4 million, thus breaching the contractual duties that attach to the full coverage under the contract, which brings us to the next issue. Judge McLean recognized that once the insurer exercised its right to defend, then Keller and Wagner had a reasonable expectation, based on the language in Condition E, that the defense would continue until Westchester no longer had the possibility of being involved in the proceeding. Condition E provides Westchester shall have the right and opportunity to associate with the insured in the defense and control of any claim or proceeding reasonably likely to involve the company. In such event, the insured and the company shall fully cooperate. Under this language, the reasonable expectation of the insureds was that if Westchester exercised its right of defense, then that defense would be pursued in full cooperation with the insureds, so long as the litigation involved the company.
But there was no interruption to the defense on the behalf of the insureds, was there? I mean, it just went back to, from the insured standpoint, it was who was writing the check for the defense costs. It went back to Carolina.
Justice Shea, as you'll see in the appendix exhibits that we have to our brief, that there was a simmering dispute at the time of withdrawal. You'll see in the correspondence from Lon Dale, who represented Carolina, he was surprised at the withdrawal. So when he wrote his letter on February 16th of 2010, he explained there was a dispute, it would undoubtedly involve litigation, there should probably be a declaratory judgment action, and we have not been kept apprised by Westchester as to what was going on in the underlying action.
But
Thereafter,
in that same letter, though, he says that notwithstanding that dispute, Carolina will assume the defense effective January 1st, 2010, which is the day after Westchester's assumption of the defense terminated. So I think your argument hinges on the actual delay in payments that Carolina ended up making, right?
well, Justice Baker, my argument hinges on the specific facts of the case, which unfolded in real time. And I think it is important that we follow that real time, because that's really the instruction of Tidymans and other similar cases. The insured's life and risks unfold in real time. And here, what the real-time events indicate was that it was 6 months after December 31st, 2009. Robert Terrazas, who was defending Wagner, did not receive his first payment for over 6 months. During that period of time, Mr. Terrazas and his small firm did not have the financial resources to pay for the experts. These restoration cases, as you're aware from Christian v. Arco and the other cases you do, they involve enormous sums of money in order to retain experts who can do the analysis of the cost of restoration. He couldn't do that. During that period of time, the scheduling order that was in effect had deadlines coming bearing down on them. The scheduling order was eventually amended to the time period that Mr. Hacker refers to, but only after the passage of these critical times and only upon the crying motion of Wagner. So real prejudice did occur, Justice. It occurred in real time, and both the attorney for Mr. Wagner and the attorney for Carolina stated that you cannot withdraw. There is a duty to defend. You may not withdraw. And they did, they unilaterally did. They did it without sanction of seeking a declaratory judgment. And at the very least, that procedure should have been followed, because you'll remember that under Condition E, whereby they exercised their right to defend and control the litigation, there was also an explicit covenant of full cooperation. Under the circumstances, the very least that they should have done was to have initiated a declaratory judgment action, which Westchester never did. And so what our position is, and the position of Judge McLean in the district court, is that under these circumstances, once Westchester exercised its right under Condition E to defend, then it had corollary responsibilities. And included among those responsibilities was to make sure that what happened never should have happened. If there was, what properly should have been done under the facts and circumstances of this case is that they should have filed a declaratory judgment action. They should have continued to defend so that the insureds were not left in the lurch. And they should have continued to defend until there was an unequivocal demonstration that there was not a duty to defend. And here, that was coupled with their contention that their insurance was no longer involved in this proceeding.
Let me ask you about this, counsel.
Yes, Justice
So
Rice.
the timing that I asked of Westchester's counsel was that they had expended their $4 million at the end of December of 2009. And at that point, they were not aware, because a claim had not been made, of any additional coverage beyond the $4 million. So upon notice, and after expending for defense costs up to their limit, they withdrew. And they indicate that there was not even a claim that they were aware of to any additional coverage until August of 2010, 8 months later, at which point the deck action was begun. So isn't that a different scenario than our breach of the duty to defend cases? And how does, and correct me if I'm wrong in this description of the record, how do these unique circumstances change the analysis, if at all?
The triggering event, Justice Rice, as is indicated in your case law, is that coverage attends the allegations in the complaint. The complaint was filed and received by the insurers in February of 2009. The allegations in the complaint against the insurers clearly included allegations that implicated both the commercial automobile and the commercial general liability coverages.
So your argument rests on the complaint then, correct?
Your Honor, that would be oversimplifying it. As Judge McLean found, it was implicated by all of the above. You need to look at the events in real time as they unfolded. Both Carolina and Westchester had noticed that there was coverage under both. Both denied that there was coverage. Both took the position that there wasn't. But as the litigation unfolded, it became absolutely clear that there was properly coverage under both. And what happened when they withdrew, when Westchester unilaterally withdrew on December 31st, 2009, counsel for the insured Wagner Trucking said, you can't do that. That is violative of Montana law. It violates your responsibilities under the insurance contract. You cannot do it. They withdrew. They didn't initiate declaratory judgment action. Carolina Casualty, that Justice Baker was just referring to, Carolina Casualty's letter that was from February of 2010 said, whoa, you can't do this. We haven't been kept apprised by Westchester. We believe that Westchester still has the contractual and legal obligation to continue to defend. So what happened here was that rather than following the well-articulated procedures that this court has set forth that are intended to protect the insureds, that are intended to protect the fundamental principle of Montana insurance law, which is to serve a protective purpose for the insureds, rather than abiding their covenant of full cooperation under Condition E, rather than following this court's directive that when in doubt, file a declaratory judgment action and continue to defend. Instead, they made the unilateral determinations that there was no more coverage available under their policy, that they were no longer involved in the litigation, they had no duties of further duties that were implicated by full cooperation, and they just withdrew.
Counsel, under Condition E, though, I mean, and I understand your position is that there was the additional coverage under the CGL, the additional $4 million, but there's no dispute that the $4 million under the auto policy was exhausted as of the end of 2009. And if that is the case, and if that was a reasonable interpretation that there was no longer any exposure of Westchester, then Condition E does preface that their duty to defend is when they have, basically when they have the exposure. I'm trying to find the exact language. I mean, if the coverage was exhausted, I mean, that's their position. If the coverage was in fact exhausted, then that did effectively terminate their duty to defend, didn't it?
Not necessarily. What we have here is a situation where it was not simply a matter of the first rights that are articulated, but it is also necessary to fulfill the responsibility of full cooperation. So what we have pointed out is that having assumed the defense under this contractual obligation, they had responsibilities as well. And the duty to defend, as this court has instructed over and over, is broader than the duty to indemnify. And so the breach of the duty to defend also carries much more severe consequences than the breach to indemnify. So in the first instance, Judge McClain found that yes, there was additional coverage under the policy because of the reasons that we've discussed. And in addition, there was a breach of the duty to defend, which brought with it the attendant consequence of being responsible for the excess judgment. I'd like to take a moment, if I could, to address the issue of reasonableness of the judgment. The Tidymans instructed, as you're aware, that there were two due process considerations. There was the procedural due process requirement, but you found that there is no such requirement under our due process provisions. Tidymans holds that where an insurer presents arguments as to the reasonableness of a stipulated judgment, the district court is required by substantive due process to hold a hearing, but the type of proceeding is left to the sound discretion of the district court. And here, Justice McClain undertook such a proceeding and carefully considered during the course of the proceeding, there were submitted to the district court voluminous expert reports that had been prepared in the underlying litigation. depositions, affidavits, and he conducted a half-day hearing. He carefully considered the expert reports. He looked at the judgment that was rendered and found and details all of the reductions that were made so that it was offset for the settlement that had been reached with the owner of the cargo. It had been reduced for the remediation equipment that could be used by the homeowners. And he, as I said...
Counsel, why was the confession of judgment, or excuse me, the reasonableness conducted here in Missoula County when the confession of judgment was filed up in Lake County? And this is kind of like having the liability determined in one county and then picking a new jury to determine the damages in a different county. I mean, it seems, and Westchester's point is, it seems logical that the reasonableness should be determined where the confession is entered.
Justice Shea, I think that it's an open question. I think as a matter of law, the reasonableness determination can be where the interests of judicial efficiency require that it be held. Here, there was litigation going on in Lake County, and there was litigation going on in Missoula County. Judge Langton, in the Lake County case, decided that it was efficient for the district court's efficient use of time to await what Judge McLean found in the insurance litigation in Missoula County before ruling. I think that that's a reasonable approach. I think that it fits with the due process concerns that were articulated in Tynan's, and indeed, he did have a very extensive reasonableness proceeding. He carefully considered the expert reports for the homeowners experts. He considered the experts' reports that were developed by Keller and submitted by Westchester, and what he found was that the judgment amount was appropriately based on the reports that detailed the costs of restoring homeowners' properties to their pre-contamination condition, and he had found that the amount was reasonable because, and I'm quoting, a jury in the underlying case could have granted the amount based on the evidence presented by the proponent of the judgment. As you're aware, this is the standard that district courts use at the time when considering motions for directed verdicts or motions J and OV. So as a result, it's a well-developed standard and it's a reasonable standard. Yes, Justice Baker.
The question is, I understand the argument Westchester was making today is that the judge couldn't make that decision without considering cross-examination or evidence that the excess insurer presented. Can you address that argument?
Well, I can, Your Honor. As you know, under Tydemans, you articulated a standard that the burden of establishing that the judgment was not reasonable rests on the insurer. And Westchester failed to offer any substantial, credible evidence that a jury could not have found on the J and OV directed verdict standard, that a jury could not have found that the amount of the excess judgment wasn't supported by the detailed expert reports of homeowners experts. So they simply did not meet the standards required for a reasonableness review that have thus far been articulated by the court, most recently in Tydemans. With that, I think that Tydemans is distinguishable. There, the concern was collusion. There was no indication of any collusion here. We produced in discovery all of our communications regarding the settlement negotiations, and it simply involved no collusion. Nevertheless, if error occurred, it was harmless error. As a practical matter, Judge McLean was far more familiar with the expert reports in the underlying action, which had never been submitted for Judge Langton's review. As a matter of principle, to remand to Judge Langton to conduct yet another reasonableness hearing would violate the mandate of Rule 1, which directs that our rules of civil procedure be construed to secure the just, speedy, and inexpensive determination of every action. Thank you, Your Honors.
Mr. Hacker, before you get started, there's a burning question I have. And Mr. Sullivan referenced, and it was one that kept bubbling up as you were first addressing us was that one coverage was left untapped. I guess if you could address that, with the insured had paid a premium that reflected two coverages, and if you interpret the policy the way that you're advocating us to do, it basically does leave that CGL policy untapped.
Well, a couple of answers. First of all, the underlying policy, the CCIC policy, was the policy with the CGL coverage and a separate aggregate, general aggregate limit for that. And I'll get to this a little bit, but I want to emphasize, it's hard to emphasize more clearly that the insureds themselves, the insureds themselves, up until Homeowners Council got involved, themselves did not think the CGL coverage was implicated here, the primary CGL coverage. Except the excess insurance is different in that there's a single general aggregate limit of $4 million. They already got from the excess insurance everything that they contracted for, everything that they paid premiums for, was a single general aggregate limit of $4 million. So there's no question of, even if there should have been separate CGL coverage, if they'd ever sought it in a timely manner from the primary insurance, that wouldn't change the amount of excess insurance that they contracted for, which was a general aggregate limit of $4 million. I would also underscore, turning back to the duty to defend question, which is where this comes up, if at any point along the way, somebody had said to us, there's CGL coverage, we of course would have promptly ceased defending because the CCIC policy would not have been exhausted. And we wouldn't defend even by the exercise of our rights if there was primary coverage still available. And nobody ever said that to us. So there isn't any real question about the CGL coverage affecting the duty to defend.
But I'm not clear. So are you saying there is or there is not, under the Westchester policy, both an auto and a CGL policy?
They're not written the same way the primary. If you look at the CCIC policy, it's a bunch of different policy forms stapled together, literally. The excess policy is just one policy that's like an umbrella, it's an excess, that just says if you meet $4 million in occurrence, or up to $4 million we'll pay for that occurrence. We won't pay more than $4 million per occurrence. We won't pay more than $4 million general aggregate for whatever is covered. It's not like a separate CGL, separate auto. The one thing that's separated out is the PCO coverage, which then actually doesn't exist. It's the general coverage.
They paid a premium, a higher premium that reflected both of those coverages, is that correct?
To us, they paid a premium that reflected $4 million in general aggregate coverage. And they got that. They got $4 million in coverage that they don't have to pay because that we immediately lived up to our indemnification obligations and immediately paid $4 million. They didn't pay for, as they could have, as in Weyerhaeuser, as in the Unigard case that they themselves rely on. And Unigard was exactly the kind of policy they want this one to be, where in Unigard, the excess policy says the aggregate limits applies to, explicitly said this, there's an endorsement that was added into that said the aggregate limits apply separately to each of the underlying coverages. That was written into the Unigard policy, and it's exactly what was not written here, because this was simply your basic excess coverage that anybody with an umbrella policy might be familiar with. You have specific coverages, for different kinds of problems at the primary level, and then an excess policy that simply says you have up to, but no more than, $4 million for anything that rises up to the level of this policy.
But isn't it a reasonable reading when you say in the condition A, the follow form provision, that you're basically incorporating and you say it'll be interpreted, this policy shall apply in the like manner as the underlying insurance described in the declarations, and the declarations specifically provide for two separate policies, a CGL and an auto.
No, maybe I'm totally my fault for not being clear. We absolutely do cover CGL risks. We cover auto accident risks. The CGL risks would include different coverages, personal injury, bodily injury, advertising injury. Our policy covers all of those. And that's the sense in which it follows form, but it doesn't follow form as to the limits, because it has specifies a different limit. It specifies a single general aggregate limit of $4 million and a per occurrence limit of $4 million. So again, they got everything they paid for, which was a general aggregate limit of $4 million. They could have purchased an excess policy that says you have $4 million in aggregate coverage for under the CGL coverage, you have $4 million in aggregate coverage under the under property damage or under auto, whatever they wanted to do, but they got a single policy, which is perfectly common. It's not at all unusual to have an excess policy that says it's a general aggregate limit above everything that might occur below and might be covered below. That's the sense in which we're following form. We're not following form to the limits of liability, which, to be clear, are specified in Declaration 6. The conditions, the insuring agreement says we will not pay more than the limits specified in Declaration 6. Declaration 6 is perfectly clear. Neither the insuring agreement nor Declaration 6 says anything about the limits prescribed in the underlying insurance in Declaration 5, described in Declaration 5.
Did the Carolina insurance pay the $1 million limit on the CGL?
I don't know, but I don't think so. Certainly not at the beginning. There's a separate agreement that they have that they've worked out with the insurance, and they're paying some amount of money. I don't know whether it's technically under the CGL or not. That's not part of the record in this case. But they didn't at the relevant time. And I think it's so important to emphasize, I couldn't agree more with my adversary that real time matters, right? You need to look at the real time timeline of how this played out, at least in terms of the duty to defend. It started after the lawsuit, the underlying action was filed in, I believe it was late 2008. It comes to Westchester. Keller, in seeking a defense, Keller itself, the insured, in a letter that's in their own appendix, written dated March 2nd, agrees that there's a $4 million limit, agrees that it will be exhausted upon the expenditure of $4 million, and doesn't mention CGL coverage. This is Keller, the insured's own view. So if we're asking ourselves, what would a reasonable insured think about this policy and all of these questions? It's answered in this case by the insureds, the two insureds in this case, who are reasonable insureds and reasonably read the policy to mean exactly what the excess policy describes in Declaration 6, which is a single general aggregate limit. We, in turn, agreed to defend only up to $4 million. We withdrew on December 9th. Now, my adversary mentions the fact that after that, counsel for the insureds complained, well, why are we withdrawing? You shouldn't withdraw. That's true in the letter in February 2010. That letter is sent. But the letter doesn't say that the policy is not exhausted. The letter doesn't say there's additional $4 million in CGL coverage. The letter doesn't say the complaint implicates CGL coverage. All the letter says is that the duty to defend in Montana law is broader than the duty to indemnify, so you have an ongoing duty, which would be true as to the primary insurer. It's not true as to the excess insurer, because that principle, of course, only applies when you have a contractual duty to defend, and Condition E of the excess policy says, with no ambiguity, that the excess insurer never, not ever, has a duty to defend. It just doesn't exist under the excess policy. The only kind of defense that might ever be provided by the excess insurer is if the excess insurer, Westchester, exercises the right that is prescribed by Condition B to associate in the defense. It never has a duty under the policy. It only can exercise a right. The next sentence.
But what about the fully cooperating
Yes, right.
clause? Because that's what the plaintiffs are arguing, is that the full cooperation under the real time of this case required that to be sequenced.
Right. That provision is, on its face, only applies when and to the extent you exercise the right. It says in such event, which is when we exercise the right to cooperate. And what it means is it's really a right in favor of the insurer, to ensure that the insured doesn't shut the insurer out and allows the insurer to participate and understand what's going on in the case, so the insurer can control the potential liability. There are exactly 0 cases in all of the United States, Montana, anywhere else, that have ever construed that cooperation clause, which is a completely standard clause in an agreement like this. When the insurer has the right to associate, both parties have to cooperate if the insurer exercises that right. There are no cases that have ever read that cooperation clause to say that, and it also means that having exercised the right, the insurer is prohibited from ever stopping the defense until the end of the case, particularly where, as here, the policy elsewhere says that there is no duty under the policy to provide a defense.
Well, what about, though, I'd come back to the statute then, if you did still have a duty to indemnify, and I understand that's one of the disputes we have here, that the $4 million is exhausted, but if Caroline, the $4 million kicks in after the $1 million Carolina policy has been exhausted. So if the duty to indemnify remains squarely on Westchester, and if there is still an amount left within the policy limits, then under 2811-316, the duty to indemnify, or excuse me, the duty to defend is linked to the duty to indemnify, but irrespective of what the contract says.
Except you're overlooking 313, which says those rules only apply, quote, unless a contrary intention appears, which makes sense because you would never want to say to insured, and that's what this rule would be saying, you are prohibited. You insureds in Montana are disallowed from going out and purchasing a policy that doesn't have a duty to defend. In Montana, all policies necessarily have a duty to defend, and you can imagine how much more expensive those policies would be. So for good reason, the Montana legislature said, sure, if you have a duty, any indemnifying party, insurance company or anybody else, may have a duty to defend, arising linked to, as you put it, the duty to indemnify. But they also took care to be sure to say that if the parties privately disagree, don't want to do that, and don't want to have a duty to defend, they're of course free to contract however they want and free to agree that there is no duty to defend, and that is unambiguously what Condition E provides. One other point I'd like to make is with respect to the MCS 90. The first point I would make about it is it's not relevant to the duty to defend at all, in the sense that even if you accept, and I wholeheartedly resist this, but even if you accept that A, it creates an ambiguity, and B, therefore, because of the ambiguity, you have to read the policy as creating $8 million, not just $4 million. That's not relevant because we had no duty to defend under the policy, and we made clear that we were only going to provide a defense through the exhaustion of $4 million, and we lived up to that promise. It wouldn't matter if it unambiguously said, this policy provides $8 million in indemnification, but no duty to defend. We were absolutely free under Montana law to say, we will provide a defense through $4 million, but not after that, absent a demonstration of prejudice, and that can't be made here, given the fact that there was a full year before the trial occurs. The last point I'd make on this with respect to, the MCS 90, they're relying on a provision that by its terms only applies to the amounts prescribed by the endorsement. That's the amount that's owed under the endorsement, which is different from the policy limits. And the case after case is construed that as saying it doesn't affect policy limits. You still have this ongoing duty under the MCS 90 to make the payment, and any prior payment doesn't affect that. That's all that language provides. So that's not relevant even as to exhaustion. The final point that I would make with respect to the excess policy is, what was the excess insurer supposed to do if it wanted to provide for a single general aggregate limit? It used the words one would think would create a single general aggregate limit, which is there's a general aggregate limit of $4 million. It's not clear to me what else one would do or say to be clear that there's not two specific aggregate limits, each applicable to each of the underlying coverages. This language is unambiguous, and if you want evidence of how a reasonable insured would understand it, you simply need to look at the real-time relationship. The reasonable insured here, the insureds, not the Homeowners Council, the insureds never thought, up until their conversations with the Homeowners Council, that the CGL coverage applied.
Counsel, just briefly on the reasonableness hearing, other than cross-examination of the homeowners experts, what do you think should have been done in the reason? I mean, if we were to revamp this, what should the reasonableness hearing entail other than cross-examination of the homeowners experts?
Well, the two things that didn't happen were, first of all, it has to go to the right decision maker. The wrong decision maker made it here. And second, they have to apply the right standard, the right rule, rather than only looking at one side's evidence and deciding whether it's sufficient. This is in order to get to a reasonableness hearing. Now, at the reasonableness hearing, if that's the nature of your question, which didn't happen here, I think it would be up to the judge. I wouldn't, if I were you, I would, and I'm not, I would be loath to prescribe too many details of what that hearing should look like.
But do you think that the record should be reopened is my question, or we bound by the record that exists?
Well, the record that exists includes our effort to put more evidence in that the judge refused to listen to and wouldn't let us take more discovery on that. I do think we would be entitled to try to make that argument to the district judge. I don't think this court needs to opine at this time whether or not, what the outcome of that proceeding should be. If we have good arguments that we didn't get sufficient discovery on that, we should be allowed to make them, the judge can review them, and then it'll be subject to review by this court in the normal course.
Thank you.
Thank you.
This now concludes the argument in this case. I want to thank both counsel for excellent presentations. The matter will now be taken under advisement, and we will issue a ruling in due course. Thank you all for coming.